It is my pleasure to welcome you to Mediation is definitely not the poor cousin of arbitration. My name is Jerry Kariuki, and I will be the moderator for this session. My panel 5. It was the intention of this panel had happened to engage in a highly interactive mood mediation so as to bring to your knowledge and senses just how very effective mediation is. Well, next year perhaps. So in lieu of that, and now that we are fully reflective of diversity, we thought to prepare you by picking your interest with our choice of subject line and laying a foundation for that highly interactive mood. Watch this space. A brief look at the questions posted during the course of this week certainly conveys the amount of interest that the topic has garnered. Well, we aren't going to disappoint you, for in the next 90 minutes, my presenters are going to keep you glued to your seats as we share with you the joys and secrets of mediation through our vivid oral illustrations in griot style of why this particular ADR process has come to be regarded as a panacea of sorts on the dispute resolution spectrum. Interlaced with a poll or two, so ticking the interactivity box, and peppered with answers to the questions that you may have posed. We intend to convert you to our way of thinking and rid you of your negative energy where mediation is concerned. Without further ado, and with no need to dwell on the specifics of our presentations, as the description contained in the conference brochure has already given you an inkling of what to expect from us, I wish to introduce my panelists. With me today is Shola Adegbonmire. You will find her a description of who and what she does on page 37 of the conference brochure. Also with us is Nicola Muriuki, whose credentials are placed on page 35 of the brochure. Please do look her up. There's Olivia Matovu from Kampala. She's on page 37. Isn't she gorgeous? And finally, our diversity, Dr. Adeyemi, who's actually in charge of this conference and can be found on page 17 should you need to know more about him. Now, without using up any more time, let's move ahead by listening to Nicola first. We each have 15 minutes, and I have requested my panelists to please try and keep time. She's going to speak on what is mediation and why should we choose to mediate over arbitration or litigation. Litigation, of course, we know why, but why arbitration? So Nicola, the floor is yours.
Thank you very much, Njeri. And let me take this opportunity to thank all those at AFA for organising such a successful conference. It's been a pleasure to prepare this session for you with Njeri and my fellow panelists. So I'm going to talk briefly for the next 10 to 15 minutes about why we should all be considering mediation. And I'm just going to share my presentation with you. Hopefully you can all see the screen. So, why mediate? Before we can consider why we should be mediating, I want to touch briefly on what is mediation. Mediation is a voluntary, non-binding, confidential, structured negotiation, which is facilitated by a neutral third party who has no decision-making power. So, You may have heard about this definition before, but it's important to properly unpack the elements to appreciate the benefits of mediation. So your parties must be willing to engage in the process. It goes without saying that this is key to a successful mediation. It is non-binding. Discussions are held on a without prejudice basis so that parties have a safe and confidential place to explore the issues unless and until there's an agreement as to terms and a settlement can be signed. It is confidential, which has two elements. It's confidential to the outside world and it's confidential as between the parties. During the mediation process, which I'll come to, there will be, or usually are, one-on-one sessions between a mediator and a single party. And the discussions held in that one-on-one session remain confidential unless the party gives the mediator permission to exchange and share that information with the other side. Mediation focuses on parties' interests and objectives and not necessarily the issues in dispute, the legal issues, I should say, in dispute. And this is not always necessarily what can be achieved in arbitration and litigation, which I will come to later. Importantly, parties have autonomy to decide on any terms of any mutual acceptable agreement. The mediator remains in charge of the process, but the outcome is solely in the hands of the parties. The mediation process. I want to talk briefly about this. You know what mediation is, but do you and your clients know what it really involves? Do your clients really appreciate the benefits of mediation? So before any mediation, preparation is key. You first of all need to choose a mediator. Now this can take up a whole separate discussion, but I would say that personality and style of any mediator is critical to the success of a mediation. Like arbitration, when you're selecting your arbitrators, your tribunal, you may use your own experience of individuals, you may seek recommendations. Costs and conflict of interests will also come into the equation. But what does your client need in terms of a mediator? Do they need a tough, straight-talking person, or will your client be more receptive to somebody who is more gentle and will take the time to think about the issues? Once you've identified your mediator, parties will need to sign and agree on terms of a mediation agreement. This will cover things like confidentiality, importantly, the mediator's costs, are they going to be shared or borne by one party, the date, the time, the location and the attendees of any mediation. All of those elements are completely up to the parties. So where does the role of the lawyer come in? I've highlighted there case summaries. It sounds simple, but there's a considerable amount of work for us as lawyers when preparing our clients and preparing ourselves for any mediation. It goes without saying, and I'm sure many of you already know, you need to know the facts, the issues, the merits of the case inside out, as well as the prospects of the success, so that you're readily informed and able to negotiate on the day. You need to assess what the other side's position is and what your client really wants to achieve out of the mediation. When you're preparing a case summary, you'll share it with the mediator and the other side. You may choose to provide supporting evidence because it's your opportunity to put forward the most persuasive position of your client and make sure that the mediator is up to speed on the key elements in order to get the most effective mediation. You'll also need to prepare your client on the process. And I've highlighted in this slide a brief overview of what a mediation involves. The mediator will manage the process, which can be tailored to the wish of the parties, but in general terms, the mediator will open with an initial joint meeting where parties will be able to provide an opening statement, and the mediator will use that to open up lines of communication, which then may lead to one-on-one sessions, which I had mentioned, where the mediator will explore the issues, not the merits, with each client and talk about what can be given in terms of information back to the other party, which would form the basis for the negotiation, and testing of the client's position, which is not always possible to do when you're having the client-lawyer relationship. That having that third party can be key to have that as a sounding board. But hopefully all goes well and your parties are able to reach a settlement. And it's very important to make sure the settlement agreement covers all relevant issues. So now I've given you that whistle-stop tour of what mediation is and why, and the process itself. Why are we talking about this? Why is this session in place? Why are we mediating? We've seen a recent interest in mediation in Africa. Some of my panelists or fellow panelists are going to talk about that in more detail. But I think it's certainly come to the forefront in recent months, and it has very many benefits. But before I touch on the benefits, I just want to talk about a few things. One, is it provided for in the parties or in the agreement that's in dispute? I haven't come across many MEDARB clauses in my time, but I'd be interested to hear from the audience of their own experiences. I think they're certainly becoming more common in recent times. The other instance is maybe, has your tribunal, when you're engaged in arbitration, ever provided for mediation? Certainly the ICC rules include it as an option that the tribunal should be considering at a case management conference, and there's also reference to it in the rules of the NCIA. I wonder whether we're going to be seeing more of that in the future. But back to the fact as to whether mediation is in your client's best interests. It's the position of this panel today that it is, and it certainly should not be perceived as the poor cousin to arbitration. And there are 5 key reasons why I say you should be considering mediation for your clients. The first one is party autonomy. Yes, arbitration gives parties a certain amount of autonomy, but mediation gives parties complete flexibility in terms to decide the process and also, as we've heard, the facilitator. Of course, our clients are guided by us as their learned counsel, but they're empowered to decide the resolution to their dispute on their own terms, and contrast that, as we know, when you hand over that control to a tribunal. Importantly, mediation facilitates communication. And as I mentioned earlier, sometimes what has brought parties to us as lawyers are not necessarily the dispute itself, but also the issues that have led up to the dispute, which can be both emotional, financial, and practical. For example, let's say you have a client who had a supply agreement with a member of his or her extended family. A dispute arose and the other side delayed providing goods to your client to frustrate them, and your client's now suing them. Extra layer is your client is under pressure from new investors who've recently come on board because of bad press that's been circulating because of the dispute and because of the legal claim that's being pursued. Now, mediation gives you a forum to facilitate communication, and the mediator's role is to discuss all of these issues, because sometimes talking about these issues can lead to proposals, as we know, of apologies or joint press statements, or future business relationships. And once parties start talking about those elements, sometimes it's enough to get parties to put a financial offer, or an acceptable, I should say, financial offer on the table. All of these things are common sense, but sometimes they're overlooked as parties have become so entrenched due to these very issues, which is what has led them to you. I've also mentioned here, number 3, early evaluation. Mediation even in an unsuccessful mediation, parties have had the opportunity to either show how strong their case is, or it has given them the opportunity to assess the difficult issues and what might be achieved through the alternatives of arbitration and litigation. And this reality testing can be critical in how you either settle or how you move a case forward in the event that the settlement cannot be reached. Now, coming to what the client is most concerned about, time is money. Mediation in any case saves you and your client time and money. All clients are very busy. They begrudge having to spend money on lawyers, especially litigators and arbitrators. And what they want to do is save money and move on to make more money. Now, Shola and Dr. Edemi are going to discuss some of these issues from a lawyer's perspective because we also have these concerns. But what your client needs to know is there is going to be a cost. There will be a mediator's fee. There'll be venue fees unless they're at the lawyer's office. And there will be lawyer's fees because, as I mentioned, mediation often requires a front loading of work. It's not that you don't do anything at all. You actually do a lot of work in preparing for a mediation. So there is going to be an element of lawyer's fees. That said, it's comparatively cheap. And as I've mentioned, even if in the unsuccessful mediations, it inevitably will save your client time down the road. And lastly, confidentiality is a key benefit to mediation. I've discussed this already, but in light of the other benefits, my position is there's no winner and no loser to a mediation. In the event that you can settle on terms, it's a decision that both parties are comfortable with and they can walk away with their heads held high. In the event that it's not successful, it's without prejudice, and so parties can then move on and fight their battles before a tribunal or in the courtroom. I'd like to conclude with a table kindly provided by Njeri, which shows the benefits of mediation as opposed to arbitration and litigation. You can see it has a traffic light system. I would say green means go. So we should all be going with mediation now and in the future. My position is there's no disadvantage and it's the opportunity to engage more clients. It's a win-win for all involved. I know it's not always perceived this way, and I know Dr. Edemi and Shola are going to talk about this shortly. But I hope this has provided you all with a short refresher and has got you thinking about those files on your desks and whether it's time to start thinking about mediation. Thank you very much for your time.
Thank you so much, Nicola. I do believe that we're starting to see or have a few converts to our cause. But just to be clear, what is the intersection between mediation and arbitration? Nicola, that sedate waltz that you've just taken us through will buy us a few converts, but let's see if you can just clarify on that one question.
The difference between arbitration and mediation, the key difference is parties decide the outcome of the dispute themselves. What financial sum are they going to agree on? What other terms are they going to agree on? They do not place it in the hands of the mediator. Remember, the mediator has no decision-making power. The mediator might walk through issues with the parties, but certainly will not impose a decision on the parties. Whereas we all know before a tribunal, we as parties agree to be bound by the decision by the tribunal that's given in any award.
Thank you very much, Nicola. Now, without further ado, let's go on and listen to what Dr. Adeyemi has to add. As I said, I know we're getting a few converts here. He's sharing his screen and he's going to dance us through what mediation is not. Dr. Adeyemi, the floor is yours.
Thank you very much. Thank you very much, Jerry. I'll just try to waltz through, like you said, and see if we can get some more converts away from Nicola. Well, the first thing I want to deal with is misconceptions. Some parties, and especially counsel, I've always wondered or asked the question, what exactly is mediation? In fact, when you Google mediation, sometimes you get responses on meditation. So there's always a confusion. When you tell people that, oh, I'm a mediator, they go, oh, so what do? You meditate, you pray, what exactly do you do? So there's some misconceptions. Mediation is not meditation. Yes, it is spiritual like everything about life, but it's really not a religious process. It's a professional event where a neutral third party helps parties to listen to each other and to get to the bottom of the dispute with an amicable settlement. It's not counseling. And this is very popular, especially in family mediation and sometimes workplace mediation. Parties expect you to give them some advice, to encourage them, to help them heal. Some even want therapy, so it is not a counseling session. It's also, what you say, it is non-binding, or it's a voluntary process in the sense that the decisions reached are owned by the parties, and the outcome should immediately be enforced or abided with. There should be no need for enforcement. The parties should normally agree to carry out what they've agreed to do, whether in a construction dispute or in a banking dispute or in a medical dispute. The parties should allow you to bind them. It's also not adjudicatory. In other words, at no point will any mediator under the evaluative, transformative, facilitative, whatever model of mediation, we have over 100 of them. At no point will he be given a decision like a judge. So even though parties sometimes will want you to come to a point where they say, okay, tell us what to do, or how do you think this dispute should be resolved? It is not an adjudication process. The parties must discuss and frame their own solution. Again, some misconceptions is that it's a non-legal ADR process. And so counsel especially don't like to take part in mediation because they feel people also want to go and talk. But it is really a very professional and intense process. And especially when you're discussing contractual disputes, it must be in the background of what exactly is the matter. Is there any crime involved? Is there fraud involved? Was there misrepresentation? Even though when parties come to mediation, they suspend their legal rights, but they mediate in the shadow of the law. So counsel have a real, very good role to play in mediation, especially in, for instance, victim offender mediation. You find that, yes, you need to also know if there should be a prosecution or compensation paid, etc. Again, some people feel that mediation exposes the strength of their case, but it's just a stopgap on the way to litigation, not especially in court-ordered mediation. So they want to hide the fact, they want to pretend, they want to push the other party to the wall to see how strong he is, and they feel that, in fact, a party dragging the other party to mediation it shows that your lawyer probably advised you that you don't have a good case if you go to court, and which is really a misconception. It's not that I opt for mediation doesn't mean I don't have a strong case. It simply means that I probably value relationships, or I feel that that matter should be dispensed with in the middle in a good time. Again, it's not right for high valued conflict. Mediation can run from $5 to dispute over a cat entering the neighbor's compound, crossing the fence, and run into multinational disputes. And yesterday at the sessions on ICSID, investor state on the ISDS, we found that even in high valued investor state disputes, mediation is now being considered and being used to settle them. So the value of the dispute is not so much important. The mediation as a process can fit into resolving any kind of dispute. So these are just some misconceptions, maybe some will come from the audience later. Now, what are the keys to a successful mediation, and what are the obstacles we face? I'm going to run through them as a practitioner who has done this for some time. One, mediations work because parties want them to work. Party autonomy is most expressed in mediation. You know, in arbitration, when we talk about party autonomy, we have the rules allowing us for default proceedings, where a party refuses, especially the respondent, to appear before the tribunal. But you can't have a default mediation. The two parties have to be at the table. So mediations work because parties want them to work. And it's very, very important that we note that. Again, parties enter the mediation process with the expectation that the matter can be settled. It's very important that they have a positive state of mind. If they come with low expectations or just a look and see approach, and they don't actively own and take care of the process, then we'll find that mediation may actually not work. A positive state of mind is very important. Number two is good faith. You don't come to a mediation merely to buy time. Sometimes you have people making insult offers in mediation or taking very strong position in negotiations because they don't want to take care of the process, or they don't want to even abide with the agreement. So they just take it that if I can buy 6 months in mediation and then I default, then you will now go to court. So I will obtain 6 months before the court action. And so this means that parties who come to mediation must come with good faith and take the process seriously, because it's just as good as any other ADR process. Again, level of authority. This is very important where you have, for instance, bank customer mediations or workplace mediations, when the management sends a very low officer, maybe the HR department, or just an officer, a manager, to represent the company in negotiating in a claim for compensation by an injured worker. Now, that mediation is not going to probably work because the person at the table can represent, but doesn't have the authority to settle. So it's important that parties who come to mediation should send the appropriate person who can take decisions on their behalf. Those who are necessary pillars in that conflict or dispute should be at the table to discuss. Again, it's flexible because mediation allows for caucuses. You know, when you're in arbitration, especially, you can't have ex-parte communications with the parties, but in mediation, the mediator can break up into groups, meet the counsel alone, meet one counsel alone, meet the parties together, meet the parties individually, all with a view to understanding the conflict and helping the parties arrive at a situation. So in mediation, we have really a case of expect the unexpected. Parties will come into the room blowing hot, and when you finally bring them down, they calm down, and once they hear the other party's position and understand where they are coming from, we move towards settlement. Also coming to mediation with realistic expectations. Parties come to mediation claiming general damages, specific damages, punitive damages, etc. You know, it's a process where you come to talk, and you need to be realistic in what you are asking, because when you hold unrealistic expectation, it's difficult to settle such conditions. Also, I find that mediation sometimes are not successful because parties are not well prepared. The mediation is an assisted negotiation. The parties have started speaking, exchanging letters, exchanging emails, and so when they can't continue, they brought a third party in to help them facilitate the discussions. And so they must understand their case and be able to present it properly. So if you're asking for a certain sum of money, for instance, you must be able to prove that it covers your hospital bill, your out of work expenses. You must be able to show why you're asking for those sums, not just a general sum that can be proven. So parties should prepare well. We talk about having the BATNA, the WATNA, which is the best alternative to a settled agreement, the worst alternative, and then a zone of possible agreement. This must be prepared by counsel and the parties or the parties alone, so that when we are negotiating, you have something to anchor the negotiations and the discussions on. Again, willingness to listen. One of the keys in mediation is active listening, hearing the other parts. When you're in litigation, parties don't speak, the counsel speaks for them. And of course, they embellish and they highlight what they think will be the strength of the cases. But in mediation, you listen to the other party, you know where they're coming from, you know what their interests are, what their needs are, as opposed to their positions alone. And this allows you to take an informed decision as to if you want to proceed and settle the matter. Again, I've mentioned about having a very good negotiating strategy. Coming to mediation with a principle or with a position that you're not going to shift. I want to get 10 naira and an apology, or I want to get $500 and an apology. Yeah, it's very, very important. You must be flexible in your asking. So you must be willing to use very good negotiating tactics. Things that make negotiations fail, of course, negative state of mind, inadequate authority, unpreparedness, and general lack of bad faith, and sometimes lack of knowledge in the process. You know, I've had parties come before me, and by the time they actually understood the process properly, they began to take better interest, better parts, and some even went ahead to be trained later as mediators. So especially counsel, some counsels come to mediation for the first time, and it's important that the mediator actually explains the process at the beginning in the opening statement, so that sometimes you want to go to caucus with the party, and the lawyer says, you can't talk to my client without me being present. You know, so these are things that must have been explained from the beginning, so that everybody knows what is going on, what to expect, and then it flows seamlessly, and the ground rules, so forth. And then also adjournment to mediation. There must be no pressure, no time. I think it's misconduct to put parties on the clock and not to allow them to again express themselves. So mediation is party driven, it's party owned, and I always say that a well mediated matter does not need an enforcement. Parties should seamlessly just go out, continue their relationships, and do what they've agreed. So mediations work because parties want them to work. And when you approach a mediation with adequate preparation, right frame of mind, you dramatically increase the mediation's chance of success. Thank you very much, Jerry.
Thank you, Doc. That, I hope, has explained to our audience how important it is, first of all, to be a good listener in mediation. And secondly, also, come to mediation with a positive state of mind. I do believe our numbers are stacking up now. That was, you've led us a merry dance, and I think we've all enjoyed that, Doc. I just have a quick one. I just have a quick question, sorry, for you, which I noted from the chat. Why are most practitioners in African countries so averse to adopting mediation as the first option in a dispute?
Okay, yes. Like I did mention, I'm sorry, many parties are uninformed about mediation. Um, I, of, 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 of every 10 parties I meet, it is usually just one or at most two who have ever been in a mediation before or even understand what it's all about. So don't really, I think, why there's an others for mediation. You see, it's important to know that what you discuss in mediation is without prejudice. I could take you to court for $1 million, and in mediation, I could be negotiating to take $100,000 from you at full and final. Now, if that doesn't happen, I will revert to court and ask for my $1 million, and I will probably even add time and cost to it. And everything we've discussed in mediation, you can't bring it as further evidence. You can't amend your pleading, because many lawyers feel that the parties want to go to mediation and then later proceed to amend their claims or defenses based on what they've had in mediation. I'm not sure that judges, and most judges now are trained in mediation, will allow that. They will disregard such evidence. So I think really it's a lack of information, lack of knowledge, exposure to the process that will make such people be advised.
Well, through this webinar, I'm really hoping that the interest is going to grow. And I do agree with you that it's lack of knowledge, and I think a lot of sensitization needs to go ahead throughout the African continent to enable people to understand that really this is one, it should be used as a first option. And in any dispute. We have a question up. Do you routinely use mediation as a form of ADR? Please, those present, vote and let us see what your responses are. Only 5% of you have voted so far. So let's see, 10%. And I think the ones who are watching us are up to 77. So I'm going to give you a few more seconds before I bring this to an end. Still going. Dayami, is there anything that you might want to say on regarding your experience as far as mediation is used in your jurisdiction?
I found out that again, I think as most parties come to mediation, go through the process, find out the benefits, they usually in their next dispute make it the first choice of dispute resolution before they litigate. So in many tenant landlords or in many commercial disputes, I did a franchise mediation once, and I found out that immediately we sorted out the issues with the franchisees, they wanted me to even give them resident mediators, like a dispute board. But they realized that they had over 100 matters in court with their franchisees, and that it was time to get those matters out of court and start looking at them in-house.
Wow.
I don't want even their lawyers, in-house counsel, trained as mediators. So I think, yes, really, the more you are exposed to mediation, the more you quickly become a disciple. So in that sense, maybe mediation is a religion, a way of life.
I tell you, I have to agree with you. Once you're exposed to mediation, you'll go with it the whole way. You only have 33, 26 people. Okay, you've closed it. You want to share the results, Doc? I think only 54% have been used to have used mediation regularly, and 38% have seen. There seems to have been fewer who have seen med-arb clauses in agreements. Well, looks like our convertees stacking up, but let's keep working. I think we can get rid of this one now. So now, our next presenter is Shula, and she is going to drum up further support for mediation by throwing light on perceived challenges that are trumpeted by naysayers to rub mediation's face in the mud. Shula, the floor is yours.
Thank you. My screen. Okay, good morning, and it's good to be here this morning and to speak on the same thing. Mediation is not a poor cousin to arbitration. Sure. Okay, let me try and share my screen. Okay, share screen. Okay, I think this is it. Is it? I'm sharing it. Yes, okay. So mediation is definitely not the poor cousin, definitely not. First of all, there's some things that just musing over this topic, mediation is not the poor cousin to arbitration. It's sad that we've gotten to that point that many people think, and even from the polls that we saw a few minutes ago, we could see that a lot of people are not familiar with mediation. Some have never seen a MEDAP. And in the poll, some said, I'm not sure what this is. And interestingly, mediation is the ADR mechanism that has been with us from the very beginning. Most of us would have heard about mediation, done mediation. We've done it, our parents have done it, our grandparents, great-great-great-grandparents. It's been with us in Africa from the very beginning. So that actually should be the main thing for us. But somehow we lost it to arbitration, and we started seeing mediation as the poor, lowly, and definitely not glamorous cousin to arbitration. And it became more prestigious to be an arbitrator than a mediator. If you ask most people, do you want to be an arbitrator? Do you want to be a mediator? Most people want to be arbitrators. There are more people applying for arbitration courses than applying for mediation courses all the time in Lagos, and I'm sure in most places. If you ask somebody, I want to give you an arbitration appointment, I want to give you a mediation appointment, which one do you want? Most likely they'll choose the arbitration appointment. But fortunately, things are gradually changing. I mean, it's nice to see, like, at this point, I think we're about 70 something or 80 something people on this panel, so obviously things are changing, and mediation is gradually rising in profile, like arbitration as an ADR mechanism, not only at the domestic level of husband and wife and small things, but even at international level. ICSID, ICC, all the big ADR institutions have now been giving mediation a pride of place, and this has been boosted by the coming on board of the Singapore Convention, which the next panel will talk about. Now, the challenges, we've heard about what mediation is, tips about mediation, how to make mediation work, but why are many people running from mediation? Why do many people look down on mediation as the poor cousin? It's because of the challenges that are perceived, in mediation. And many people here are lawyers, and some who are not lawyers have also had one thing or the other to do with mediation, and they have these challenges that they think make mediation the poor cousin. Mine is, are they challenges or are they perceived challenges? Because it depends on where you are looking at it from. I'll take 4 challenges. There are a few other challenges, but the major 4 challenges that I hear people talk about all the time, parties complain about it, lawyers complain about it, and so I'm not doing mediation for this reason. And I'm sure many of you will agree with me. Please put it in the chat box and tell me what you think about these challenges as I speak. Number 1 is enforcement. Oh, we can't enforce it the way we can enforce an arbitration award or a court judgment. 2, lack of compulsion in mediation. You can't compel parties. We start a mediation, and in mediation they can walk away. Once you start an arbitration, you can't walk away except both of you agree. Then 3, opportunity to earn income. I don't know if many of you have heard, but a lot of people, a lot of lawyers especially, they call mediation ADR. And the interpretation ADR is alarming drop in revenue. Do you think mediation is alarming drop in revenue, ADR? They say, oh, you come to mediation, parties don't pay so much money, the matter is settled in a very short time. I'm sure many of you have heard the joke of the old man who was very angry with his son, who joined him as a lawyer, came into the law firm where his father had been practicing for maybe 20 or 30 years and said, Dad, I went to court and that matter you've been handling for 30 years, I've settled it. We just had a quick mediation. And the father was very angry. Who told you to settle it? I've used this case to send you to school, and I intended to use this case to continue sending all your junior ones to school, but we've settled it in mediation. So, is there an opportunity to earn income in mediation? And that is a big challenge for many people. And number 4, capacity of the mediator. Many people feel, oh, the mediator doesn't have capacity. So we'll just look at these things one by one, and we'll do that quickly. Enforcement. Now, usually what happens at the end of a mediation if you settle? Well, what usually happens if you settle is that there's voluntary compliance. Voluntary compliance when you settle. Because in mediation, even as Dr. Belusi has said, it's usually a win-win. and it's usually the decision of the parties. It's not the decision of the arbitrator, it's not the decision of a judge. When it's the decision of a judge, one party wins, one party loses, and then the party who loses does not want to comply. Same thing with arbitration. But with mediation, it's the decision of both parties. So usually, parties have voluntary compliance because it's a win-win. So that's what usually happens. Voluntary compliance. Voluntary compliance is not that common in arbitration and mediation, especially in at least in our jurisdiction. A lot of people still want to go to court after arbitration, after litigation. They want to go and set aside the arbitration award. They want to appeal the judgment when it's a judgment. But with mediation, usually, because it is the decision of the parties, they comply. Occasionally, you have a party who feels that he has not won. So he sees himself as the losing party, and then he does not comply. So what happens when the losing party does not comply? Because that is one of the challenges. Well, we have to understand that when there is a settlement, it is a signed contract, and you can get a summary judgment in many jurisdictions. Most lawyers just assume, oh, you know, if we settle and it doesn't comply, we have to go back to court and start all over again. No, it's not like starting off all over again, because there is already a settlement, which many jurisdictions now see as almost a court judgment, or they give summary judgment. In fact, in places like Lagos State, for example, even if it's a private mediation settlement, the Lagos Multi-Door Court can endorse it and then have it enforced as a court judgment. Of course, if it's a court-ordered mediation, then automatically the settlement is endorsed as a court consent judgment and it's enforced as such. So it's not such a challenge anymore, because if you have settlement and one party does not comply, then in many jurisdictions, it can now be enforced. Like I said, in LMDC, in Lagos, you can bring it to the LMDC, pay a small fee, and they will enforce it the same way they will enforce a court consent judgment. What generally is the rate of success in mediation, which would encourage lawyers because it makes the client happy? The rate of success in mediation is always much higher than, because when you have success, it's followed by enforcement, voluntary compliance, how many cases. Just as an example, in September 2020, even with the pandemic, the total number of cases received by the Citizens Mediation Center in Lagos was 1,277, out of which 801 cases were successfully resolved in 1 month. That is 62% of cases fully resolved in 1 month. Next thing, let's look at lack of compulsion. A lot of lawyers complain, I don't want to do mediation because parties can walk away at any time. It's a waste of time if you get halfway and one party just says, I'm not going through. Well, first of all, when it is court annexed, the rules usually not only compel parties to attend, but encourage parties to see it through. The way this happens is that the courts penalize people who do not see it through. So the court has sent you to mediation, you've gone there and you've just been very difficult. The mediator will write a report. The mediator is expected to write a report to the court, and the mediator's report will show what has happened in the mediation. And this, the court can use when it is deciding on award of costs to those who don't support the process. And of course, if it's a private mediation, that's different, because in private mediations, parties have usually paid for it anyway. So it's not likely parties are going to pay and then they won't see it through. You know, they pay a lot of money, so they will usually want to see it through. They're not going to walk away because they have paid for it. And that's why if it's court annexed, the court backing helps make parties stay. If it's private, their money they have paid makes them stay. Now, some will say, oh, it happened in one mediation I handled or in one mediation I attended with my client. The other person just walked away, so I am not doing mediation again. Please remember that every mediation is different. And so the fact that it has happened in one mediation does not mean it is going to happen in another. I come to the greatest challenge, what I think is the greatest challenge for most people. It is income earning. can I make money from mediation? The same way I can make money from arbitration, or the same way I can make money from litigation? Okay, let's look at these questions. What are the benefits to me as a mediator? I mean, for me, one great benefit is that I get the satisfaction of helping people settle disputes and make money at the same time. I get the satisfaction of solving problems for my clients within the shortest possible time. I know that for most clients, they just want their problem solved. They don't want me to make QC out of their case. They don't want their cases to go on and on. They don't want to spend all their money just going to court, all their time going to court. So I get the satisfaction of satisfying my clients. And when I satisfy my clients, I will make money. So how do I make money from mediation? Now, I'm looking at it from two angles. How do I make money as a mediator? How do I make money as a representative of a party, usually counsel? So how can I make money from mediation? I can work as a private mediator, either as a general private mediator or as a mediator in a niche area. And there are many niche areas: oil and gas, family matters. I know someone who mediates family matters. She calls it divorce with dignity. What she does is just matrimonial matters, but people are willing to pay top dollar for having their divorce done, their problems, the issues settled quietly without showing it off to the whole world. And the whole world knows that the madam slept with the driver, or the oga, the boss, slept with the maid. All that is kept quiet. Nobody knows about that. And there are people who are willing to pay top dollar for that. I know people who do family matter mediation and charge as much as $10,000 because people want to keep their secret. And then when all that has been resolved in mediation, they just come to court and just put the cover on the coffin. The whole matter is set. Nobody knows who did what, when, where. They just come to court and they have a simple divorce. And there are people who specialize in that area of mediation. We have people who are living in oil and gas rich areas who just do community mediation. That also is a lot of work, yes. Community mediation and all those things. We have sports mediation, all those things, people make money. You can work with companies and help them do mediation audit. Many companies are complaining they don't want to spend all their money going to court doing arbitration. They're waiting for you to come in as a mediator. What are the benefits to me as counsel pushing my clients into mediation? Now, of course, like I said, many companies, the big companies, the blue chip companies, they keep telling us that our business is not arbitration, our business is not litigation, our business is our business. If I'm an oil company, I'm an oil company. If I'm Coca-Cola, I make soft drinks. Whatever my business is my business, not going to court. And so they are looking for ways to settle their disputes without spending all their money. The budget for litigation in many of these companies is shrinking, really shrinking. So they want counsel who can advise them on how to settle matters without going to court. You'll be surprised that many of these companies, and we've had meetings with a lot of these companies, conferences with a lot of these companies, who are saying, we want counsel who can help us resolve disputes without us going to court. So take note of that. That is where, somebody called, I was reading an article, make peace, make money. And that's what we should keep in mind, make peace, make money. Finally, quickly, finally, capacity. Another challenge is, do mediators have subject matter competence? Now, know that mediation is not really knowledge-based. It's really skills-based. So the most important thing is that you have the skills. Of course, if you need a mediator who is skilled in the area of a dispute, there are mediators skilled in many areas, and so you can have skill-based, knowledge-based altogether. But finding a mediator who has capacity in whatever area of your dispute is not a very difficult thing at all. And the most important is that, does the mediator have the skills for mediation? That's the most important. Now, how can I myself be trained as a mediator? There are many institutions that train. CIAB, Chartered Institute of Arbitrators, we run mediation trainings. CEDA, Center for Dispute Resolution in Europe, IM, International Mediation Institute, and they all run courses all over the world. CIR, many of us are here in Jerry, they run it in Kenya, in Uganda, in Nigeria. We run courses everywhere. Are there courses that will help me understand my role as counsel? Yes, there are mediation advocacy courses, which helps you to understand your role as counsel and how you can make money as counsel from mediation. The Standing Council of Mediation Advocates, they run such courses. They teach lawyers how to be on top of mediation and how to make money from mediation. So mediation works well, and there is money in mediation. In conclusion, I'll say most of the challenges that counsel and parties raise against wanting to resolve their disputes through mediation are perceived challenges, and the rewards far outweigh the so-called challenge. There are opportunities in mediation for counsel, there are opportunities for mediators. I mean, you resolve parties quickly, harmonious relationships continue. Your clients are always, trust me, your clients are always very pleased with you. I will just end this with a story that I always tell when I teach mediation. I had a matter in court, and we had been in court for about almost a year. On my way home one day, I saw this gentleman who said, "Oh, hello, how are you?" I didn't recognize him. And he said, "Oh, you don't know me?" I said, "No." He said, "I'm the lawyer on the other side of that particular case." I said, "Oh, you look so different." He was wearing jeans and a t-shirt. And he said, "Can't we just resolve this matter?" And I said, "Why not? Let's try." Anyway, we got into negotiation, and within 1 or 2 meetings and calls, we had resolved it. What would have taken another maybe 5 years, 7 years, all the way to the Supreme Court, because both parties had deep pockets, we resolved within a week. When I told my clients that, "Oh, this other party says if you pay this amount, they would settle the matter," all he asked me is check or cash. And I realized that our clients are not wanting to spend all their time in court. What they want is a quick resolution of their disputes, which puts mediation high above as the rich cousin of arbitration. You will make money, you will finish many mediations. You could have done 10 mediations in the time it takes you to do one arbitration. I'm sorry, I didn't have time. I wanted to tell you how much fees. I mean, ICC, I think it's about $21,000 on the average. And the fees for mediation, some jams is $250 per day, whereas arbitration is $400. But in a shorter space of time, you've settled many mediations before you settle one arbitration, or even 1/10 of a litigation. So I hope, as we used to say in school then, when we used to have these debates, I hope I have convinced you that mediation is not a poor cousin of arbitration. Thank you very much.
Thank you so much, Shola. That I tell you, even brava, brava, brava. I have somebody here on the chat who is saying, "Fantastic presentation."
Thank you.
Round of applause for you. I know that our convertees have increased 100-fold at this point in time with that drumming that Shola has done and just laid and just laid flat all those perceived challenges. If you're not sensitized at this point in time as to why mediation can never be regarded as a poor cousin of mediation, by this time you should know that mediation just rocks. Okay, and Olivia is going to bring up the last part of our session by giving us a glimpse into what the history and tradition of mediation by speaking on future perspectives and online mediation. Olivia.
Thank you, Jerry. Greetings to all of you in our different time zones. I'm glad to be here. And I want to thank my panelists. Wow, that was very fantastic. Now I think I am the cake for this mediation party. So I hope the icing will be just fine by the end of it. So allow me to share my screen. All right. As probably Nicola told all of you, in mediation, it's party autonomous. And most importantly, parties must know each other. So I begin this presentation by introducing myself so that you as our mediators in the room can know which party this is. My name is Olivia Charimpa Matovu. I am a lawyer by profession, a partner at Legal Mark Advocates, a law firm in Kampala, Uganda. I head the training and accreditation arm of the International Center for Arbitration and Mediation in Kampala. This is a new center in Kampala for dispute resolution services. That is Olivia Charimpa Matovu. Now, in mediation as well, we must know the details about the parties. For example, if you're the mediation counsel on the other side, you must understand the opponent, what makes them tick. It means you must do research about them to be able to understand how to negotiate and sway them to your side. So for now, I'll just tell you who I am, such that when we meet on the other side, you know what makes me tick. I am a mother, I'm married, I am an advocate, as I already told you. I have 15 years experience, but I look young. Jerry, that's right. I still look 25. I head the training and accreditation arm of ICAMEC. I'm a member of the Chartered Institute of Arbitrators, United Kingdom. I am a member of the Young International Arbitrators Group of the London Court of International Arbitration. Like I said, I am young. As a lawyer, I'm a member of the Uganda Law Society and the East African Law Society. And I'm a member of the arbitration cluster, having been its former chairperson. On top of that, I lecture and teach. So we have areas of commonality with my panelists. We are passionate about teaching and about resolving disputes through mediation. So what does mediation really mean? Nicole already gave you the definitions and even told you what it's all about. But what's very critical about mediation is that even when you have an agreement, the question is, do you all have the same principles? In other words, when you agree in an agreement that you've resolved your dispute, are you going to actually enforce or comply with your agreement? Do you have the same principles? Are you clear about settlement? So as we convince you to come towards mediation, it's important that we know that mediation is meant to end the dispute and not to buy time. So we must all come to the table with the same principles to close and not to prolong and buy time. So I will give you a glimpse into the definitions of mediation. Obviously, Nicola did, but my colleagues bullied me and said, Olivia, you must do research and show us the authorities as lawyers. So I said, all right, and right there, their definitions. Obviously, they don't change from what Nicole already shared with you, but when you look at our presentation, you can refer to those materials as modes of definition. And I'll just specifically refer to the one of Uganda because I'm a Ugandan. Our Judicature Mediation Rules 2013, the ones that govern mediation, court-annexed mediation, define it as a process where a neutral third party facilitates communications between parties to a dispute to assist them in reaching a mutually agreed resolution of the dispute. The rest you can read on your own. I'm giving you homework such that you can see what other writers have written. And obviously you'll add more into your literature. So what's the glimpse into history? Why do I have to take you to history? It's because we are now making you converts. However, you must know that we've been with mediation since time immemorial. So it's not a new concept. It has always been there. We just need to know that it's part of our history. So mediation, it comes from way back. If you look at the European merchant law, the tossing of the coin principle, that came as a way of resolving disputes among the European merchants. There was no law really at that point. And the story behind the tossing of the coin is that two merchants were angry at each other over a business disagreement, and they all marched going to fight. And one old man came running and says, oh, gentlemen, calm down. And then they all turned, to look at him. What is he saying? And then he told them, why don't you toss the coin? And whichever side each of you has chosen, where it falls, then the person whose side will be on the top is the one who will have won. And indeed, the gentlemen who are going to fight and flex, boxing, in a boxing match, toss the coin, and the dispute was resolved. Since then the merchants decided that, we don't need to fight, to quarrel much. We can just agree. I take this side of the coin, you take this side. Let's flip it, and we'll decide our dispute. When I go to Shola's, where she comes from in Nigeria, and Dr. Ademe in the Yoruba dispute settlement in Nigeria, Shola, you'll confirm that. I'm not Nigerian, but for my research, family disputes were brought before a Mojaji, I hope I've pronounced it well, who was a clan head, and a Bale, an elderly head of the district. So, for example, if there was a fight between husband and wife or children in the home, adult children, the disputes were taken before those elders in society to enable them resolve them amicably. And what was the purpose? To allow harmony, to allow relationships to continue, because where they go and the decision is handed down by, let's say, an arbiter, then both sides remain angry, but these people would sit them together, make them see reason why they need to settle as a family, and then they go back shaking hands as brothers and sisters. So we've been with mediation. We've had it in Europe, we've had it in Nigeria, and I'll show you that we've had it elsewhere. We've also had it in China. So for our Chinese colleagues, please, you'll send more information as part of your contribution to this discussion. But you have the Chinese Confucian ethics. And in the Chinese culture, they believe in harmony in society and the universe. And because it's part of their cultural beliefs, they believe that you must settle disputes amicably. And if you can't settle them between the two of you or three of you who are in disputes, then you get a neutral third party to help you. And they did not believe in forcing a decision on parties. So we see that even in the Chinese culture, mediation was there. Okay, and even before it was formally made, even the governments in resolving political disputes decided to embrace it. We see that after the fall of Kyung, I don't know how they say it properly. Is it Kyung, whatever, however they mention it. Chinese, please forgive me. You'll guide me in the pronunciation. It says that before the establishment of the People's Republic, the government, the communist government, established mediation under their rule to resolve political disputes and other disputes in society. So you can see that even after being cultural, even the politicians embraced it as a form of dispute resolution. Now allow me go to my home, Uganda, the Pearl of Africa. And I will say, Jerry, do not kill me, but I was biased here. I had to start with my own country just for you to see us first as the beauty queens, then we can go to the next. Thank you. So how is mediation in Uganda? Let me give you a history. We also have it in our cultural setting. Traditional mediation has been held before council elders in our tribes, in our different tribes. And today I want to share with you that it has been held in the pastoral communities of Karamoja and Iteso in the northern region of Uganda, and it continues to be held there. And these are, they would fight over land, grazing land and animals. So the cultural leaders would then sit with the disputing parties and then help them mediate the dispute, and then there would be an agreement. So we have it as part of our culture. But in terms of the formality of mediation, it began as a court annexed mediation method, because in terms of the formality, most of the practitioners, even parties, were used to litigation. So the judiciary of Uganda, together with other partners, development partners, decided to have it as a mode of dispute resolution in Uganda to help in resolving the case backlog in the courts. So it began as a pilot project in this country, and it began in 2003. So there were rules that were enacted to enable that process start. After it was done, then an amendment of our law was done in the civil procedure rules. That was in 1998. I'm sorry, in 1998, first there was a recognition of ADR, but the actual mediation was recognized in 2003. So then it began as a pilot project, and subsequently then it was embedded into our civil procedure. So now, as it were, all civil cases, before you go to trial, you must attempt mediation, and there must be a mediator's report on the file before a judge actually determines the dispute. So if the report is there, it's either saying parties failed to settle but attended mediation, parties partially settled the dispute. And we have seen that along the way, many disputes have been resolved through that process. And as a result of the growth of ADR and particular mediation, we have 2 ADR centers in Uganda that are working together to promote ADR. That is the Center for Alternative Dispute Resolution, CADA, that was introduced in 2000 through our Arbitration and Conciliation Act in Uganda. And then we have the ICAMIC, the International Center for Arbitration and Mediation in Kampala. And this is the new kid on the block where I head the training and accreditation arm. So those 2 centers are promoting ADR in our country. And then I want to continue with this case study. So as a result of the court annex mediation, we have seen a growth of private mediations. Parties are now opting, even before going to court, to actually appoint mediators on their own, and they've gone ahead to mediate disputes. And how are these mediation agreements enforced in our jurisdictions? Those that are done through private mediations, for you to enforce it, you first go to court through a suit. In case the party doesn't comply, you file a suit against the party as if the agreement were a contract, and then you enforce it. That way, the court will pass down a judgment or against the party who was defaulting. If it was a court annex mediation, and probably the party has failed to comply with court annex mediation, the result is a consent judgment. So the parties go ahead. The decree holder, I should call them, consent decree holder, goes ahead and applies for execution in the courts in our country. And as a result of success of mediation, we have seen that even our appellate courts have embraced it as a way of resolving disputes at the appellate stage. So we have an appellate mediation at the Court of Appeal, which began in 2016, and indeed a number of appeals have been closed. What is unique about them is that in this case, parties do not change the judgment. In other words, if the judgment came down to state that a party was fraudulent, the mediation would not say the party was not fraudulent. But what the courts have said is that you can agree on rights. For example, as a result, somebody was granted damages of $100 million. You could agree and say, okay, I'll take $50 million instead of going through litigation for another 5 years. So in that way, we find that cases have been settled. Allow me now go into Africa. Obviously, this is the Africa Arbitrators Association. So indeed, we speak about Africa. For other continents, forgive me, I may not talk about you, but we know that there's mediation in your jurisdictions. So in Africa, I was again biased. Why? Because my panelists are from the different countries. I'm beginning with Kenya because I have Njeri and Nicola here. So I mean, I had to showcase them. So is there mediation in Kenya? Yes, it is. That's why Njeri and Nicola are here to share their experiences and their knowledge. And it's recognized in their constitution under Article 159. And Kenya also had to champion mediation through the pilot project under court annex mediation. So as you can see, I've quoted for you the rules under which they commenced it. And the principle was still the same, that all civil suits must undergo mediation before it's taken before a judge for determination. So I believe, Jerry, you'll confirm that a number of court cases were resolved at that level, and it helped in reducing the case backlog in Kenya. And we see that Kenya is moving fast. As of last year, they now came up with a mediation bill. In Uganda, we don't have a mediation bill. We just have the rules of court that govern mediation. However, the mediation bill would govern all mediations, whether private or court annexed. And we see that in Kenya, they have already come up with a mediation bill. Jerry will confirm that it has already been made an act, but it's intended to enforce both court annexed and private mediation, and obviously also promote the Singapore Mediation Convention in enforcement of the international arbitration settlement, international settlement agreements. Okay, before I peep at Nigeria, where is Tanzania? Ah, wow. So let's zoom into Tanzania. Tanzanians, are you there? Please put up your hands and clap, because I've also come there to showcase you. So does Tanzania have a mediation? Yes, it does. It does. As you can see, their constitution recognizes ADR. And again, in Tanzania, it was also introduced under the civil court system as a court annex procedure to allow for parties to settle court cases through mediation. So like Uganda and Kenya, it was through the same system that mediation has taken root. And I've quoted for you the rules under which Tanzanians practice mediation under the court. The principle is the same, that before a matter could go for litigation, a civil matter must go through a mediation. And you can see the case there, Fahari Bottlers Limited and another, the Court of Appeal of Tanzania indeed confirmed that if any matter were to proceed to trial, there had to be mandatory mediation. So let's peep at Nigeria. Shola, are you there? Yes, Nigeria, and Shola will contribute further when we give you time to make any further contributions. Again, in Nigeria, there's mediation. Obviously, I only chose one state because Nigeria is big with many states, and many of you who are here can share your experiences in the different states. But as you can see, the laws of the Lagos court allow for settlement of disputes through amicable ways, and under the Lagos Multi-Door Courthouse, mediation services are provided. My timekeeper is telling me, so I'm just going to run through the rest of the slides. Nigeria continued there. You'll see for yourselves when you receive the slides that indeed even in Nigeria, mediation is recognized. Okay. So what are the trends in mediation? Allow me, Jerry, conclude. Thank you. What are the current trends in mediation that I have seen, and probably you'll share whether you've seen the same? We have seen a growth of private mediation. So whilst before it was compulsory under court, now we are seeing parties on their own pursuing mediation in private sessions. And I've given an example of some mediation center. I've given one in Kenya. Then under the multi-tiered ADR clauses, we have seen an advent of such clauses where negotiation is the first step, then mediation, then arbitration. So we are seeing that the ADR methods are now being used as an escalation point. So mediation is now being encompassed in there, and parties are encouraged, before you arbitrate, please consider mediation, and it's an agreed part of the contract. Then the Singapore Mediation Convention, obviously, which is going to be talked about by another panel, I won't say much, but really its intention is to promote enforcement of international mediation agreements. And what does that then mean? That might be at the same level as the New York Convention in enforcement of international arbitration awards. So is mediation still a poor cousin of arbitration? I doubt. They are all now at the same level in terms of international enforcement. And then there's online mediation, which is the new kid on the block. COVID opened our minds to so much, including online mediation. That will be a topic for another time. I won't go into the details, but you know that online would be the same way we're talking here, and that's how we would mediate. So with these new trends, colleagues, friends, mediation is definitely not the poor cousin of arbitration. They are running toe to toe, and let's embrace it and work together to promote it. I thank you very much all for listening to me. And before I close, allow me give you a quote which says, angry words are like a feast. And that's like arbitration and litigation, because usually we are using angry words, but the tongue of the wise brings healing. That's an African proverb. A mediator enables parties settle, gives them wise words, and they bring healing, and relationships are rebuilt. Thank you once again, and please join the mediation crowd, join the party. Thank you. Thank you, Jerry.
Thank you so much, Olivia. That was really a befitting way to come to the end of our presentations. Thank you so much. As one person says here, oh, there's another poll. One person has just said an inspiring presentation. I congratulate you, Olivia. It was lovely. Thank you so much. We now have at least 12 minutes, besides the polls that we're giving you, to answer a few questions. And quite a few have been asked on no, not a few, there are only 3 at the moment, and we're going to answer all of those besides a few others that I had picked up before. And as you complete your polls, I think my panelists and I will start on one that one person was very had questioned. Can the same individual act as both arbitrator and mediator in the same proceedings? I'm tossing that into the hat. Would anybody like to respond to that one? Or shall I do it for you? Yes, I have acted as both. I have started off as arbitrator and ended up as mediator. There are a few rules. If the mediation does not succeed, you, at least as far as I'm concerned, some other people say you can act as both. But as far as I'm concerned, no. Once you've acted as mediator, the best thing you can do for you and your parties is to leave the stage and leave the arbitration to somebody else to resolve. However, there may be some issues that have been settled within the mediation, and these will be passed on to the new arbitrator to be included in the final, or even the, no, sorry, it would be a consent award that would be issued by the new arbitrator, okay, having drawn up a settlement, and then passed on to the new arbitrator, who will then finally draw up a consent award. Of course, you as mediator, in case you're worried, you've already been paid. Okay.
Yeah, I
So
think
you agree, Doctor?
I agree with you, yes, because many parties do contend that if you mediate a matter and then proceed to arbitration to settle it, at that point in time, there's no longer a dispute, and that's really something you don't want to test. So, yeah, you should leave this scene and let someone else take over.
Absolutely. Nicola, I can see you want to add something.
Yes, I agree with both of you. It's again about how parties perceive the process. At the end of the day, the parties are paying the bill, whether it's the mediator's fees or the fees for the arbitration. And if as a mediator, you've had those confidential one-on-one discussions with either side, you will have learnt about things that you might not necessarily have passed to the other side, because again, it's about what the parties have allowed you to exchange. But then if you are then sitting as an arbitrator deciding an award, even if you're not considering those ancillary issues, you're still aware of them. So clients, we're human beings. Naturally, you will wonder about bias. Whether you can challenge it or not is another matter, but it's going to be a problem for the parties. That would be my position.
Thank you very much, both of you. The poll results are out. I think we have, wow, now we have, when is the best time to propose mediation in a dispute? Before litigation, 87%, and 13% say when in court. Given the choice, which will you choose to settle a dispute? Wow, we're up to 61% for mediation. Arbitration is at 13%, med-arb is at 26%, and litigation, thank God, is at 0%. Looks like our converting has worked, people. That's excellent. I just want us to dwell a little more on something that Shola had brought up, and this was on the accelerated decline in revenue. This is one thing we really, really need to let go of, because once we switch our minds to working with volume, which I think Shola really emphasized, moving disputes along. What do you want to do? You want to resolve disputes for your clients. They'll be so happy with you if you resolve these disputes. And I promise you, you'll be moving files along, and the word will get around that you're one of those people. As an advocate, you're able to assist your clients to resolve. So, is there anything that anybody would like to add to this discussion? And I have people raising their hands too.
Yeah, Olivia, I want to speak.
Yeah, please go ahead, Doc.
Yeah, well, like Shola did mention, in terms of client satisfaction, do you want the clients to be in the dispute forever, or do you want to resolve it? For instance, I did a matter that was 30 years in court. They've gone through the lower court, middle court, Supreme Court, and we're back again to the lower court and going to the middle court again. And there were 12 parties. By the time I finally resolved the dispute, only 4 were alive. And I remember the first thing he said when we signed the agreement was, now I can get on with my life. And I felt, wow. So yeah, his life had been locked up in that dispute for that length of time. And I think that's really what parties should think about. When parties come for dispute resolution, yes, they are clients, yes, they help to pay the bills, but they're human beings, and they're going through a lot of psychological and difficult and emotional trauma. So we should also look at different ways. ADR is a toolbox. From mediation to arbitration to med-arb to neutral evaluation, we should look for the best as a practitioner and not always make litigation the first choice.
Precisely that. Now, I've seen somebody raise their hand. Emeka Onyeka, was there a question you wanted to ask? I think did you want to say something?
In the chat box.
Yeah, why don't you put it in the chat box? Yeah.
Jeremy, something on the closure and the money element?
Yeah, just say something as we try and also answer some of these questions. We have 5 minutes. Just go ahead.
Just quickly for me, in addition to what Doctor has just said, I think the psychological fatigue is not just for the clients, even us as practitioners. I mean, handling a case for 5, 10 years, 20 years, it's exhausting. The mental fatigue, the stress, on top of that, even the value add, you get bored. And yet when you close quickly, I mean, the energies for a new case are better than a case has been going on for 20 years. So I think it helps all of us, parties and the practitioners, to close and move on to the next thing.
Thank you so much, Olivia, for that. Let's just answer a couple of questions. What do you do when a party fails to abide by the mediated settlement? One of you perhaps could answer that. And the other one is the mediator expected to address all issues raised by the clients, or he or she picks up the most important issues to handle? I think that's one of the MSA. Who can answer that? Nicola, please do the second one about the issues. Who would like to do the first one? What do you do in a party? Maybe Shola. Shola, can you answer that, please?
Okay, because I think Doc wanted to answer it.
Okay, go ahead, Doc.
Yes.
Yeah, Shola mentioned it when she was speaking. And yes, like I said, mediation is not an adjudicatory process. Parties may come before you with several issues, but as the conversation continues, the ones that are most important to them come to the fore. So you could have a tenant-landlord dispute that comes before you, and by the time they're talking about it, there's a bit of sexual harassment, a bit of intimidation, there's a bit of theft. So several these things come up in the course of the mediation. And so really the issues are never yours to throw up. The parties in the course of talking to each other and will eventually highlight what are their true needs. Sometimes it's an apology, sometimes it's really a clear understanding of your position, and that's why it's a very wonderful process, very, very flexible.
Nicola.
Sure, we've had a question from Spencer. He says, indeed, a lawyer has a role in a mediation, gathering the evidence, but is the mediator expected to address all the issues or pick out the most important issues to handle? I would say, again, the mediator is going to be solely guided by the parties and the parties' lawyers. And in my presentation, I talked about the preparation of the case summaries. That's your opportunity to highlight what the key issues are for your client. Because again, it's all about what the parties want to achieve. And the mediator, yes, will pick out those key issues at the mediation itself. But if there are things that have been missed, or there might just be matters that come out through the course of the conversations with the mediator during the mediation itself, it's solely in the hands of the parties.
There's a final question, and I'd like Shola to please deal with it, from Miss Glory Igwe.
Yes, she wants to know if parties are really willing to listen once they've got to court, or mediation is just delaying the evil day. I mean, that I really want to answer, because I have found out that mediation is not delaying the evil day. With court-ordered mediation, many people come to mediation when the court orders it. And I tell you, they're not happy to come many times. They come grudgingly because they feel the court has forced them. But over and over and over again, I have seen it. When you follow the process, people begin to relax and they find out that mediation is actually a better option. I have seen it so many times that people come from court to mediation, and then one, they are heard in mediation. In court, they are not heard, only their lawyers are heard. They begin to hear themselves in mediation. I've seen many times when one party says, oh, I didn't even know you are like this. You know, so they're hearing themselves, they're being heard, and they're able to relax. And they find that they can actually talk and move things forward better in mediation. Over and over, you know, I see it when people come, they've closed themselves up to everybody. But once the mediator begins to apply the process and the skills, the soft skills of mediation, they begin to relax, and many times it works. And that's why we always say the process works. Thank you. That's just what I wanted to say.
Thank you, my panelists. Thank you so much before we get cut off. And I think we've won the day. Seriously. I think we need to give ourselves a big pat on the back. Thank you, all the attendees, for all your lovely comments. Have a wonderful day and the rest of the conference. Please enjoy.
Thank you.